The first question is is the trademark liable for removal on the ground of non-use?
Yeah, so
Okay.
let's wait for the answers. No, hold on. Hold on to the
Yeah, yeah.
first question.
Yes, I do.
Let's wait for the
Yeah.
answers. If you could, friends, put it in the chat box. Yes, no, whatever you feel like. Is the trademark liable for removal on the ground of non-use? Okay. Or any thoughts very quickly? Okay, so people are saying yes, no, no. Okay, we see more no's.
Yeah.
Only one yes. Trademark liable for removal on the ground of non-use. Okay, mostly we're receiving no's. Okay, Surbhi, answer.
So the answer for yes is yes. Your trademark is liable for removal on the ground of non-use. This is, would be surprising for all of you because if you get your mark registered and you're not using that mark, somebody else wants to use that mark. And if that person sees what is the market value you have with the mark, how often are you using that mark? If there's no proof for that, that person can approach to the registrar. The registrar can call you, send a notice to you, and you will have to actually prove that you are not using your mark or were you using your mark. If you're not able to prove yourself, then your mark will be removed and the other person will get right on that.
Oh, that's a big one actually, because you're saying that not only you can sort of register and block the mark, but you need to be using it. And if you're not using it and somebody else wants to use it, then it can like result into a sort of an opposition where you can be sort of asked to deregister, is it?
Yes, yes, that's right.
Okay.
Yeah.
Oh, that's an important one. Okay, go ahead.
Yeah. So the next one is, uh, yeah, can a registered trademark be amended at a later date? Once it is registered, if you want to amend it, can you do that?
Okay, answers please, audience. Can a registered trademark be amended at a later date? Okay, so most of the people are saying yes, but we have one no as well. But mostly it is yes. So Surbhi, what's the answer?
No, that's the answer is no. Once a mark is registered, you cannot amend it at a later date. The
Oh,
reason is the proprietor can be amended, it can be assigned, but the mark for which you have the registration number also, it can never be
hmm.
amended. If you want to amend it, you'll have to file a fresh application.
Wonderful. So see, these are so important questions where, it's very counterintuitive. Looks like if the
Yeah.
answer looks like yes, it is no, and vice versa. So, okay, looking
Yeah.
forward to the third question.
Uh, yes. Can an unregistered trademark be protected?
Okay, friends, answers. Unregistered trademark, can it be protected? So a lot of people are saying no. I'm suspecting the answer could be yes. So, okay. I think we have more no's than yes. So, but yeah, some people are saying yes also. So what's the answer, Survey?
So the answer is again the opposite of the majority. The answer is yes, the unregistered mark can be protected as well. So even if you have your mark since years that you're using your mark and you do not get it registered, you will get that mark protected. That's when I also mentioned in the transborder transactions, if you prove your presence in a particular area where you want to get your mark registered, you have proprietary on that mark. It is not important that you have to register your mark. Of course, for registered marks, there are certain other associated benefits, but with the unregistered mark also, you have the protection available.
But Survey, I'm assuming there would be a caveat here because if let's talk of India only, not transborder. I'm not complicating.
Mhm.
So I'm saying that if I have an unregistered mark and somebody else has a registered mark, but I'm using an unregistered mark and somebody else is also using, but maybe slightly lesser, but his mark is registered. So wouldn't he have a better protection? Since his mark is registered.
No, so again, that unintentional concept also comes into picture. If you both are using the mark unintentionally, you both can have the right. And second, the very important factor is the time since when you're using your mark. If you're using your mark since 2005 and that mark is registered in 2025, you want to register your mark today. If you approach the registry, of course, you will have the proprietary right than the person who has already registered its mark.
Yeah, but then it becomes litigative, burden of
Yeah,
proof, and
yeah.
all those things.
Yes, yes,
And
yes.
some bias will go to towards because otherwise, then what's the means if somebody who's got it registered very legitimately using it, and somebody who's not got registered, there would be it will become hugely litigative in a trademark litigation.
That of course will go to courts, but then if you have evidence that you're using your mark since so many years, you have that reputation in the market. So that will also be considered while considering the case.
Okay. Okay, go ahead.
What is the difference between license and assignment of a trademark? So more than a quiz, this is actually an answer that will need a detailed response.
Yeah, but why don't just need a detail, but why don't you just articulate, Surbhi? This was in fact my question also. I was about to ask this question. Good that you put it this way. So yeah, if you could answer right away.
So license and assignment are a different concept. License could be for certain number of years, only granting certain rights to the licensee. However, assignment is forever. You cannot assign for a certain number of years. Assignment is registered with the registrar. I mentioned that assignment agreement has to be in place. For license agreement need not be in place. You need not go to registrar because license today you're licensing to one person for, let's say, you want to market your product in the market. You then in case you'll be licensing your product to a particular marketing agency. But then tomorrow after 2 years you would need another marketing agency. So we need not register this license with the trademark registry. But assignment is forever. You need to get that registered with the trademark registry by filing that assignment agreement. That's how both these are
Yeah.
different.
Put otherwise, if somebody is selling the trademark to somebody, then that sale takes place in form of assignment, which is registered with
Yes.
the trademark registry, right? Whereas
Yeah.
license is a time-bound,
Permitted use. Yeah.
temporary, probably revocable license to use somebody's mark, right?
Yes, that's right. Yeah.
Yeah. So yeah, there's a comment called ownership versus mere rights transferred. So in assignment, I think the ownership of the mark goes, whereas in license, only certain limited rights are licensed. Yeah.
Yeah.
Okay. Next question.
Okay. Next is, so sweet. What is the difference between infringement and passing off with a trademark?
Yeah.
So
You can answer that as well.
answer that also. So when you say infringement,
Or let us take this as a text quiz only. So yes, anyone would like to put it in the chat box in difference between infringement and passing off. One line answer only. We are not asking you to write an essay, but yes, any one line or differentiating line between what is infringement and what is passing off. I'm sure a lot of legal professionals and company secretaries would have read it, but somebody who's not practicing it, in case you remember. Practitioners, of course, would know it by the back of the palm. Maybe people are typing. Let's see who press the enter first, fastest finger first. I'm hoping that somebody's typing. Yeah, here we have the first answer. Infringement is unauthorized use if trademark, whereas passing off protects goodwill of unregistered trademarks. So it is slightly confusing. Surbhi, only if you could sort of articulate and clarify.
so when we say if your registered mark is the only mark that is being protected, and we say unregistered marks are also protected, if somebody is infringing your registered mark, is when you file a suit for infringement. You send cease and desist notice, and an infringement suit is also filed. However, if an unregistered mark is being used by somebody else, you still have the legal remedy available with you. That is passing off in trade. In that case, you file a case for passing off that your trademark has been passed off by that entity. So that's the difference.
Right.
Infringement is for the registered mark remedy, and passing off is the legal remedy for unregistered trademarks.
Welcome to COMPLINITY Technologies. COMPLINITY is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. COMPLINITY is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances. All in an integrated platform that is easy to use with automated alerts and risk management capabilities. Is why compliance managers, general counsels and chief financial officers choose COMPLINITY every time. Join the most innovative and prestigious brands that use COMPLINITY. Automating your compliance management, request a demo at complinity.com.